Chapter 19, Checks. Section 200. Check defined and distinguished from bill of exchange. The Negotiable Instruments Law defines a check as follows. A check is a bill of exchange drawn on a bank, payable on demand. To this definition is added the following provision: except as herein otherwise provided, the provisions of this act applicable to a bill of exchange payable on demand apply to a check. In other words, a check is a commercial instrument which is in the form and nature of an inland bill of exchange, payable on demand. A check, unlike a bill of exchange, is always drawn upon a bank or banker and is always payable on demand without days of grace. It is not necessary that a check be presented for acceptance as in case of a bill of exchange. However, if the holder requests it and the banker desires he may accept it. A check is similar to a bill of exchange in that it is a negotiable instrument, if negotiable in form, and is subject to the same rules regarding its transfer. A check may be transferred by endorsement and the endorser incurs the same liability as the endorser of a promissory note or bill of exchange. Like a bill, a check must contain an order, the order must be for the payment unconditionally and at all events, and it must be for a certain sum of money. If an instrument is drawn in all respects as a check except that it orders payment at a day subsequent to its date, it is then a bill of exchange and not a check, being subject to all the rules governing bills of exchange. The drawer of a bill of exchange is discharged by default of the payee or holder in making due presentment to the drawee and in giving notice in case of dishonor, while in case of a check the drawer is not discharged by the failure of the payee or holder to take the above steps unless the delay was unreasonable. A check is not due until demand is made for payment and the statute of limitations begins to run only after that time. A check may be accepted as payment. Section 201. The formalities of a check. A check as to its form and formalities differs but little from that of a bill of exchange. All the various requisites of negotiable paper must be complied with in case of a check. There must be certainty as to amount, time and the person to whom payment shall be made, and the payment must be in money. In order that the check may be negotiable it must contain words of negotiability, but the absence of such words does not affect the character of the check other than that it is non-negotiable. Usually a check does not contain the address of the drawee, while in a bill of exchange it is almost invariably written in the lower left-hand corner. The address of the bank is usually written or printed in large letters across the top, just below the date and place of execution. Section 202. Presentment of a check for payment. The main purpose of presentment for payment being made in due time is to fix the liability of the maker in case the bank fails before payment is made. The Negotiable Instruments Law provides that a check must be presented for payment within a reasonable time after its issue or the drawer will be discharged from a liability thereon to the extent of the loss caused by the delay. This is simply the enactment of a general principle of law which existed prior to the passage of the Act. Simply the want of due presentment of a check will not discharge the drawer, unless he has suffered some loss or injury thereby. The only injury which would be sustained by the drawer in case presentment was not made within a reasonable time would be caused by the failure of the bank subsequent to the delivery and prior to the presentment of the check. Justice Story states the rule in the following language: if a bank or banker still remains in good credit and is able to pay the check, the drawer will still remain liable to pay the same, notwithstanding many months may have elapsed since the date of the check, and before the presentment for payment and notice of the dishonor. So if the drawer at the date of the check or at the time of the presentment of it for payment had no funds in the bank or banker's hands, or if, after drawing the check and before its presentment for payment and dishonor, he had withdrawn his funds, the drawer would remain liable to pay the check, notwithstanding the lapse of time. Thus far we have only discussed the effect of delay in presentment as to the maker. Now we will consider its effect upon an endorser. We have already seen that delay in presentment does not discharge the liability of the drawer unless he has sustained a loss thereby. But we find that a different rule applies as to an endorser. As between the holder and an endorser, the rule is that the check must be presented within the time prescribed by the law merchant, which is usually the following day, and if such presentment is not made within a reasonable time the endorser will be discharged from any liability. The question that now arises is what constitutes a reasonable time. The law merchant has established the rule that where the parties all reside in the same place the holder must present it not later than the next day. This is not, however, an absolute and ironclad rule. What is a reasonable rule will depend upon circumstances and will in many cases depend upon the time, the mode, and the places of receiving the check and upon the relation of the parties between whom the question arises. Section 203. Certification of check. Certification of a check is an agreement whereby the bank agrees to pay the check at any future time when presented for payment. No particular form of words is necessary, but the usual method of certification is by stamping or writing upon the check the word certified and adding the date of the certification. After a check is once certified at the request of the holder, the drawer is released from all liability and all subsequent endorsers are discharged from their obligations. The negotiable instruments law provides, where the holder of a check procures it to be accepted or certified, the drawer and all endorsers are discharged from a liability thereon. The bank, after the certification, will not be allowed to dispute the genuineness of the drawer's signature or to question the sufficiency of the funds in its hands to pay, as against a bona fide holder. Neither will the bank be allowed to deny the validity of the check on the ground that no payee is named therein, because in such case it will be held payable to bearer. The effect of certification is that the bank by certifying the check becomes the principal and only debtor, and the holder by taking a certificate of the check from the bank, instead of requiring payment, discharges the drawer. That is, where a check is certified by the bank on which it is drawn, the certification is equivalent to an acceptance. The check then circulates as the representative of so much cash in bank, payable on demand to the holder. We shall next notice who may certify a check. The board of directors as the governing body of the corporation or bank may delegate to other officers who have not implied power, the power to certify checks. The officers having implied power are the president, cashier and teller. The assistant cashier has not this power, and if he certifies a check, signing his name with his official title, cashier, without authority, it is generally held that it is not binding on the bank even in the hands of a bona fide holder. A check cannot be certified before it is payable. Thus if a check is post-dated, the bank would not be bound by a certification made before the date on which the check is payable. If the commercial character of the check has been destroyed in any manner, the officer of the bank is not authorized to certify it. If the officer certifies a check of a person who has no funds there, the bank is not bound by it except as to a bona fide holder without notice. Below is a form of certification. Detroit, Michigan, December 1, 1908. The Eagle National Bank pay to the order of Albert Carter $200. $200. John Marsh certified December 1, 1908. John Green, cash. Section 204. Forgery and alteration. The rules governing forgeries and alterations to commercial paper in general are applicable to checks. The bank is under a peculiar obligation, however, to know the signatures of its depositors on the checks drawn against it. But the bank is not presumed to have any peculiar knowledge of the genuineness of the contents of the checks. It is very common now that a check is filled out by a clerk and then signed by the maker. Therefore a bank is not charged with as great a degree of knowledge as to the genuineness of the contents of the checks as of the signature of the drawer. If the bank pays a check which has been altered in any material respect, it may recover the money so improperly paid, since the holder of the check guarantees the genuineness of its contents. The general rule therefore is that the bank is strictly held to know the signature of its depositors, and money paid on forged checks cannot be recovered. But the bank is not held to so strict a knowledge of the contents of the check because they are not charged with knowledge of the handwriting in the body of the check, since it may or may not be the handwriting of the drawer. The bank is still liable to a payee or endorsee on whose endorsement alone the check is payable, although the money has been paid on a forged endorsement. But the bank is not supposed to know the signature of endorsers, and if any of them be forged, the bank can recover back the money paid out on the check. Section 205. Memorandum check. A memorandum check has been described to be a contract by which the drawer engages to pay the bona fide holder absolutely, and not upon a condition to pay upon presentment at maturity, and if due notice of the presentment and non-payment should be given. The word memorandum written or printed upon the check describes the nature of contract with precision. In form and appearance a memorandum check does not differ from an ordinary check except that the words memorandum, memo are written upon the face of the check. Such a check is given by the drawer to the payee more in the nature of a memorandum of indebtedness than as payment. In the case of a regular check, demand for payment and a refusal on the part of the bank are necessary steps before the holder can maintain an action against the drawer, while in the case of a memorandum check the drawer may be sued the same as upon a promissory note. If such a check is presented for payment, and the drawer has sufficient funds to meet it, the bank must honor it like any ordinary check. If the agreement between the drawer and payee is that it shall not be presented for payment, any remedy of the drawer for the breach of such agreement is solely against the payee. If a memorandum check has been endorsed to a bona fide holder for value, the check then presents all the features of other negotiable instruments. Section 206. Stale check. A stale check is one where there has been unreasonable delay by the holder in presenting for payment. It is always unsafe to delay the presentment for the double reason that the drawer or endorser may be discharged by loss occasioned by the failure of the bank, and because a stale check is looked upon with suspicion, since custom has established the fact that checks are not supposed to remain long in circulation. Some jurisdictions hold that if the bank pays a stale check which for any reason may be invalid, the bank will be held to have done so at its peril, as the fact that the check was stale was sufficient to put the bank upon inquiry. It has also been held that a purchaser is put upon notice as to the genuineness of a check by the fact that it is stale. There is no absolute rule which may be laid down in determining when a check is stale. Section 207. Check holder's right to sue the bank. Let us first consider when the holder of a certified check may sue the bank, and then consider when the holder of an uncertified check may sue the bank. The great weight of authority is that where the bank has certified a check, any holder of the check may sue the bank to compel payment. The certification creates a new and binding obligation on the part of the bank. Delay in presenting a certified check does not discharge the bank from this obligation. It has been said that the obligation of the bank after certifying a check is simply and unconditionally to pay upon demand, and in all such cases the demand may be made whenever it suits the convenience of the party entitled to the stipulated payment. When the business of a bank is properly conducted, it is not possible that it can sustain any loss or prejudice from this interpretation of the contract which it makes in certifying a check, and it is only where delay may be prejudicial that the want of due diligence may be legally imputed and operates as a bar to a claim which the holder could otherwise maintain against the bank. The effect of a certification as to the right of action which may be maintained by the holder simply shifts from the drawer and endorsers to the bank. His right to sue is transferred from a right against the drawer to a right against the bank. The rule as to the right of a holder of an uncertified check to sue the bank is denied by the great weight of authority. To enable the holder of such a check to successfully maintain an action against the bank, it would be necessary for the check to operate as an assignment of the drawer's funds. This, it is plain, an uncertified check does not do, since it is but an order to pay and not an absolute assignment of anything. A check of itself does not operate as an assignment of any part of the funds to the credit of the drawer with the bank, and the bank is not liable to the holder, unless and until it accepts or certifies the check. It would seem on principle that there is no assignment to the holder nor privity of contract between the bank and the holder of an uncertified or unaccepted check, either at law or in equity. The holder's remedy is against the drawer, and to the drawer only is the bank liable if its refusal to pay was a breach of its contract. A check is clearly not an assignment of money in the hands of a banker. The banker is bound by his contract with his customer to honor the check, when he has sufficient assets in his hands. If he does not fulfill his contract, he is liable to an action by the drawer. Section 208. The depositor's right to draw on the bank. The implied contract between the banker and the depositor is that the banker will honor his checks to the amount of his deposits. Therefore it is a plain proposition that only the depositor or his duly authorized agent can draw against the deposits. The depositor is the only person entitled to draw on the bank any check whose signature does not correspond to the name on its books. In case the deposit is made by a partnership, the check must be signed by the partnership name and may be issued by any one of the active partners. Where the check is not signed by the partnership name, but instead all the partners sign their individual names, the bank may honor the check. Where several persons, not a partnership, make a joint deposit, it is necessary that all their names appear on the check unless they make the deposit a joint and several credit, in which case any one of them may draw on the deposit. As to corporations, it is incumbent upon the bank to ascertain from the charter or bylaws of the corporations what officers are authorized to draw on the deposits of the corporation. But if a check is drawn by an unauthorized officer and the corporation accepts the proceeds of the check, it is as top to set up the officer's want of authority. Where a number of trustees deposit trust funds, the general rule is that all their names must be signed to the check in drawing on the bank, but a court of equity may sanction the drawing of a check by a less number than all. An agent who has put to his private account funds of an undisclosed principal may recover damages from the bank for refusal to honor his check upon them, although he had improperly obtained them. Section 209. Failure of bank to honor check. Where the bank possesses funds of a depositor, it is bound to honor his checks to the amount of his deposits. If a check is properly drawn and presented for payment and the bank fails to honor it when there are sufficient funds, the depositor may maintain an action contract, but against the bank, not only for a breach of contract, but also for a tort. In the latter case he would be entitled to recover damages for injury to his credit or any other injury that he might have suffered. The drawer must have sufficient funds in bank to meet the check in full to entitle him to maintain an action against the bank for a failure to honor his check, because the bank cannot be required to make a part payment. After the deposit is made, the bank is allowed a reasonable time in which to enter the credit upon its books. But if a reasonable time has elapsed between the deposit and the presentment of the check, the bank will be liable although the credit was not entered, because it is the duty of the bank to properly keep its books and to properly conduct its business.